And so when the jury goes in, the trial judge gives them that Supreme Court citation, and into the jury room they go with the written instruction right out of your mouth. Now let's recapitulate, and let's cover these two lessons, lessons 21 and 22. And let's think for a moment about what we've seen and what we've learned here. We started off here talking about the grand jury, and we know that we have a reversible error issue over the grand jury. We also learned about Lysander Spooner and Red Beckman's two books. This Lysander Spooner book you can get at your local public library. You can probably pick one up at your local law library. Everyone tells me that those are the two best books out. Red Beckman now has two books out. I forgot the name of the first one right off the top of my head. But you can write to us and we'll either send you the book or you can pick it up from other patriots around. Red Beckman, remember, in Montana has shut down the IRS in Billings, Montana to 4 days a week or 3 days a week and 4 hours a day. At least 10% of the people in Montana know and understand jury lawlessness and jury nullification. One of the best things that we can do is to teach our fellows around us what jury nullification is about from Malloy and Doherty. When you go in on jury selection or when you're called for jury duty, remember you're going to have to play the part of a dummy. Otherwise you're going to be bumped off the jury. The moment that you start talking intelligently about juries, jury nullification, trying the law and the facts and things like that, the prosecutor is going to dump you like you're a hot potato. All right, so there's three items that you want to keep in mind. Now, we talked about the state constitution. We talked about the juries, for instance, in the state of Idaho at Article 1, Section 8. We know that we have a right to a grand jury investigation on each and every charge if there's 1 year and 1 day in jail. Those are called infamous crimes. Always demand that grand jury. Check your own state constitution and find out where your grand juries are pursuant to, say, Illinois and Texas. Whatever state you're in, there will be some kind of a provision for a grand jury. Now remember this also, that the federal Supreme Court in 2 or 3 cases has said that in those states where informations are lawful, that they will not interfere. Idaho is one of those states that prosecutes either by information or indictment. Remember now that the information is permission that you grant the state in order that the state may prosecute you without a grand jury indictment. So while Idaho is, in fact, one of those states that you can be prosecuted either by indictment or information, it requires your permission to be prosecuted by information. If there are any states, and when you check your state constitution and find that you can be prosecuted by information without a grand jury indictment, you've got a major federal question that needs to be addressed, and it needs to be set up right from the scene of the crime. Now, going on then to this common law, that is simply the common law jury is a petite jury. It's going to be 6 or 12. Remember that the 6-man jury started with the Phoenicians about 700 B.C. There are places in various state constitutions where the 6-man jury has been specified and spelled out. Idaho is one of those states in all misdemeanors. When you go into the traffic court, you're only entitled to a 6-man jury. That's when you're entering the court in equity, admiralty, maritime, probate, but not at common law, because the common law jury is 12 and the very definition is 12. When you walk into the courtroom, always demand a 12-man jury at the common law. Keeping in mind, of course, that a traffic court, probate courts, and other civil law jurisdictions are not common law courts, and no free man belongs in one of those courts. You ought to look around. Once in a while it gets a little humorous, you know. The judge will call you down and say you're only entitled to a 6-man jury, and he'll overrule a motion or two. I kind of look around and, Judge, did I get in the wrong room? I thought I was at common law. Where am I? Where should I go for a common law trial? And the conversation will break down, but you'll have a little humor in the courtroom. And remember, if you're not having fun at this, you're not doing it right. All right, then in Lesson 22, the last segment that I talked to you about was this thing of jury instructions, and I want to wrap it up on the jury instruction because You know, I hear complaints from citizens from coast to coast, and they just say time and again, these courts are unfair, these courts are filled with commie pinkos, and they're taking advantage of us, and they've nullified our Constitution, and they won't listen. All right? Now remember, I've said a dozen times, if I've said it once, it's not my position to say that that's right or wrong or good or bad. It's my position to say that the way the court works seems to me to be pretty good. I've done 33 cases so far, and I've won 33 out of 33. I have 4 in litigation. My record in civil actions isn't so good at this moment in time, but we've just begun to do some civil actions, specifically under Title 42, Trovers and Replevins. We have 2 cases now. One of them has been docketed before the Federal Supreme Court, which is a writ of prohibition that Bob Hallstrom has done. It's the 3rd one that I know of that's come out of our school because Lee Brobst helped some people over in Colorado and Kansas to file 2 writs of prohibition, as I understand it. And there's a writ of prohibition that someone else told me about that's been sent to the Supreme Court. A fellow from, I believe it was Phoenix, Arizona, told me. So we know of 3 or 4 that are now before the Federal Supreme Court. So whatever it is we're doing must be right, because we've got those cases docketed in Washington. Now, 3 of our students here in Boise, Idaho, have cases docketed with our state Supreme Court, and I've just docketed my very first case in 5 years of doing this. I've always been sandbagged at the district court level, but finally I've got one docketed with our state Supreme Court. We know that our procedure is correct, and we know that our strategy is correct, and we know that none of our students who have been graduates from our school have yet been defeated. And a defeat could only come at the hands of the Federal Supreme Court when they refuse certorsi, refuse the appeal, or when they rule against us, and that hasn't happened yet. Now, the biggest problem you're going to have is in arguing the Constitution to the jury, and I just covered that. You argue the Constitution to the jury in jury instructions. And I want to cover that one more time. I want to drill that into you because the winning position, if you're going to win in spite of the jury verdict or argue your case to Washington, I would say that the jury instruction is the most important step in this jury process, because this is the only way, to my knowledge, that you can argue the Constitution to the jury. Now, if there are some people on the jury who know the Constitution and are aware of constitutional rights and procedures, well, that's a plus in your favor that most often you will not run into. So taking a look at a jury instruction again, you write a jury instruction based upon the facts of the case, based upon the Supreme Court's decision concerning your status. And we go right back to Lesson 1 at status, don't we? Now, I happen to be looking at a jury instruction, and I'm going to send this little packet of jury instructions with this lesson. And keep in mind now that in Idaho we have a binder that's about like this blue binder here. And you'll find this up in our law library. It has about 1,000 jury instructions in it that cover all sorts of general subject matter, both civil and criminal. So this jury instruction gets its beginning at the scene of the crime. If at the scene of the crime your state of mind is this: officer, where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. And I'm contending, officer, that I have a right to drive without a driver's license, and that where rights are involved, you cannot compel me to sign a contract or a license. If you make that statement at the scene of the crime, you have qualified Miranda, page 491, as a jury instruction to go to the jury if during the direct or cross-examination you put that officer on the stand and say to him, officer, at the scene of the crime, did I tell you plainly about my rights? Well, yes, you did. Did I say to you, quote, where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them? Well, I don't remember those exact words. Did I say words to that effect? Well, you might have. Did I say something to you that where rights are involved, there could be no rule-making? Well, I'm not sure. I don't remember. Stay after him until you get it out of him. because the trial judge is listening to that fact. When you take the witness stand, you get on the witness stand and you say, as a matter of fact, I told Officer Smedley, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. And I told him that, and that's a fact. Now, you have two witnesses that have testified to this fact. Now, there happens to be a Supreme Court decision that is attached to that fact, and that comes from Miranda versus Arizona, 384 U.S. 432 at page 491. You submit this as a jury instruction, and if that trial judge refuses to enter that as a jury instruction, that's grounds for reversible error, because obviously the jury has a right to know what the Supreme Court or what the law is concerning your rights driving on the road. Now, the next question that comes up, well, how many jury instructions do you file? How many grains of sand are there on the beach? You may file 1, or you may file 10, or 100, or 500. There's no limit to how many. Now, the very next lesson we do, we're going to cover the subject matter of the prosecutor's half of the case in Lesson 23, and then the defendant's half of the case in Lesson 24. And I'm going to go through and I'll show you at what point in that trial scenario in the next lesson that we're going to enter these jury instructions, because I've gone into chambers, and sometimes you'll be in chambers for 4 or 5 hours hashing out these jury instructions, talking to the judge and trying to get him to put this jury instruction in. And it's up to you, after all the testimony is in, to say, Your Honor, as a matter of fact, I testified and Officer Smedley testified as to this particular passage from Miranda versus Arizona. And that's a matter of fact, and it came out at the scene of the crime. It came out in testimony both on cross-examination and direct examination when the prosecutor's half of the case, and on direct examination on the defendant's half of the case, and it's a proper jury instruction, and the jury has a right to know, and I demand that you put this in. And I'll show you how that goes in the next lesson, because the next two lessons go together also. Now that we've got the jury selected, and it's sitting over here now, let's pretend, on your right, and you're ready to move forward in the trial, there are some crucial stages during that trial procedure that are going to occur. And you're going to need to take notes on that, and that's why I'm suggesting to you, that you practice in the traffic court before you get into the district court. But now, on the jury and the jury's instructions, the petite jury, the jury nullification, we've covered about 10 or 15 subjects here, and I guess if I had 90 hours to talk about the jury, we would be talking for 90 hours on juries alone. And I had a third grade teacher tell me one time, and it's worth passing along. She told me, George, you don't really need to memorize anything. You don't need to memorize the dictionary or the encyclopedia. You just need to know where to go look them up. And the purpose of this course, and the purpose now when we focus in on juries, isn't for me to tell you everything that's ever gone down from Blackstone and Koch and Field and all of these legal writers that have written books on juries, because there's books and books and books on the jury issue alone. But rather, I think now after these two lessons, you should be in a position to do the further research that you're going to need in any particular case that you may want to do. That is, once I teach you how to spell, there's no way in the world that I can keep you out of the dictionary. But if you can't spell, there isn't any way in the world that you can use a dictionary. And that's where the legal profession has all of us, the average ordinary Joe Six-Pack, the fellow that works in the factory, the guy that's working in the office. When you walk into court, you not only don't know how to pick a jury, you don't know what the jury does, you don't know what it's for, you don't know how to use jury instructions, you can't get your issues before the jury, and the judge sits over here and says, you can't talk about that. You can't talk about this. You can't mention that to the jury. I'll hold you in contempt if you do that. And here's poor Joe Six-Pack, sitting back here wondering, well, this court is against me, and this court won't let me tell the jury my side of the story. And let me tell you, friends, I've been through that time and time and time again. And I know how frustrating it is, and I know how much easier it would be for you to just tell your story to the jury without having to write it down in jury instructions, or without having to go through all of this long, drawn-out trial procedure. And that's why the courts work that way. because the longer it takes, the more days off you have to take from work, the more expensive it is for you, and the easier it is for you to simply say, to heck with it, I'll just plead guilty and pay the fine. And as long as we do that, we'll live in Egypt and we'll make the Egyptians bricks for them, and we'll have to gather the straw to make the bricks. And that's why I keep telling people time and again, this isn't easy, but it's certainly within the realm of learning to do. It isn't that difficult if you put your mind to it. But if you can't write and you can't write up jury instructions, then I guess the only solution is for you to make bricks for the Egyptians and shut up. If you're not prepared to go to jail for a few days and protect your constitutional rights, if you can be intimidated out of them, well then of course you're talking about the brickmaker making brick for the Egyptian, not the free man who's going to cross the river. So I'd say with that then on juries, we've about covered the subject. If you'll pick up a book or two on the subject, I think that you can work it out for yourself. And the next thing we want to do then is to get into the prosecutor's half of the case in Lesson 23. So let's stop here with the jury issue, and let's get ready for the prosecutor's opening statement. Now it's time to physically go forward itself. And going forward in the trial itself seems like one of the most traumatic experiences that a human being can go through. Why, it's worse than being thrown in a pit of boa constrictors or poisonous snakes of some kind or a pond full of alligators. I think most citizens feel like they would rather do almost anything or suffer any kind of punishment or torment than to go into a courtroom. And one thing that judges would rather not go through is a jury trial. So the feeling is mutual. And when we go into that trial, into that courtroom before that trial, you become Brer Rabbit going into your briar patch. And if you'll look at it from that point of view and from that vantage point, when you get into that courtroom, you're on your own home grounds. And it may take you a couple of 3 cases in the traffic court before you're ready to take on some major topic or some major case. And I know that your heart's going to flutter, and I know mine does to this moment in time. I get into the courtroom and I go, uh-oh, here we are, we're getting ready to go, and I say to myself, well, what am I doing here, and how did I get here, and the prosecutor's sitting over here, and oh yeah, they're going to go forward, and they're going to do it to me today. All right, so since that's the case, it's time to sit back and pour a little water. You'll have water, and if you don't have water, you say, Marshal, would you bring a little water over, please? Now, we've just completed the jury selection, and so the jury has been out. You had a 15-minute recess. The jury comes back, sits down, and the judge says, Mr. Gordon, are you ready to move forward? No, Your Honor, the defense is not ready to move forward for the causes and reasons as earlier stated, and that is that without a grand jury indictment and without our motions having been heard, we're not ready to move forward. And then the judge says, well, I'm going to overrule your objection, Mr. Gordon, and we're going to move forward anyway. Thank you, Your Honor. That being the case, let the record clearly show my continuing objection. And then comes the prosecutor. And the judge will say to the prosecutor, Mr. Prosecutor, are you ready to move forward? And he usually says, at least I've always seen them say, I'm ready to move forward, Your Honor, or the state is ready to move forward. And it's at that point the trial begins. Now the judge will usually give a little statement or introduction to the jury and tell them what the case is about. Maybe takes 5 minutes and says the case is about George Gordon maliciously destroying a jail uniform and explain the ramifications and the possible penalties, and then goes to the prosecutor and says, would you like to make your opening statement now? And the prosecutor will, at that point, since it's his case, will make his opening statement. The prosecutor's opening statement is limited to simply outlining what the state is prepared to prove. It's what the burden of proof, now remember, is on them. The burden of going forward is on the state. And so the prosecutor is going to outline his case. And it'll go something like this. Ladies and gentlemen of the jury, the case before us today is a relatively simple case and straightforward. The state is alleging that the defendant, Mr. George Gordon over here, on or about April or whatever it is, let's just pick a date, January 12th, 1983, did willfully and maliciously destroy a jail uniform, the property of Ada County, and he did this willfully and maliciously with premeditated forethought, and he did this in his jail cell, and he did this with witnesses present, and we're going to produce 2 witnesses who are going to testify that they saw Mr. Gordon do this, and he'll take, 5 minutes, let's assume, for a typical opening statement on a short misdemeanor like this, and then he'll call his very first witness. And his first witness will be, well, let's say Officer Smedley, and then he'll call a couple of jail cell fellows, and these people will testify, and we're going to get into that in more detail later. But when he gets started in his case and starts calling his witnesses, that's all there is to his case, is calling 1 witness or 10 witnesses. That's all he can do. And he's going to introduce evidence. And the evidence that he's going to introduce is going to be the physical jail suit that was torn up, or a confession from me, or something on that order. So in order for us to set the background for the particular case that we're going to act out here in the studio, pick up Lesson 9. That's the case. It's called the Sample Criminal Case for Use with Videotape, Lesson 9. And flip over to Item 3. When we get over to Item 3, we find that this is Idaho Code 18-7001. And from our perspective, while we're sitting on this side of the desk, the state has to prove what's called a prima facie case. And the word prima facie simply means on the face of it. You know, you'd say on the face of it, this says legal quotations. On the face of it, this is a book. I mean, it's self-evident. You can see it. You can touch it and taste it, and it's right there in front of you. And that's what the prima facie case is for the state. And they have 6 minimum prima facie items that they have to prove. There could be 10 or 15 prima facie facts that they have to prove in order to gain a conviction. And a conviction in a criminal case is beyond reasonable doubt. That's not beyond a preponderance of the evidence, such as in a civil case, but beyond a reasonable doubt means that they don't have to prove it beyond a moral certainty. I mean, they don't have to prove that this is a book beyond certainty, just beyond a reasonable doubt. And the reasonable doubt is, if there is some doubt in your mind based upon your experience in life and the way you live and the way you conduct your work and drive your car and water your lawn and feed the dog, if based upon those experiences the facts and the evidence you hear persuades or convinces you that the logic of the circumstances are such that your common sense tells you he must have done it, then you should find him guilty. But if, on the other hand, there is some doubt in your mind based upon your experience, something that once happened to you that would say, well, you know, it could be the way he said it happened, okay, then you're to find him not guilty. Now, the first thing from our perspective that we want to do, we want to set up as our defense, is the statute itself. And the way I do this is that I take the statute, and you'll see number 3 here, and let's just read through it, and then let's write down several of the facts that he has to prove in order to prove that I'm the fellow who did this particular act. The statute reads, malicious injury to property, Idaho Code 18-7001. Every person who maliciously injures or destroys any real or personal property, not his own, in cases otherwise than such as are specified in this code, is guilty of a misdemeanor unless the damage is caused by a violation of this section exceeding $1,000. If it exceeds $1,000, in which such person is guilty of a felony, and shall be punishable by imprisonment in the state prison for not less than 1 year, nor more than 5 years, and may be fined not more than $1,000, or by both such fine and imprisonment. All right? So the first thing I did is I went through and I attacked the statute, and I want to plead the code. I want to show that I can't even come within this statute. So in my motions, I've already brought up the subject matter, that this is a civil law, that the civil law cannot apply to me because I'm a common law citizen, and that it requires intent as well as the act. Let's suppose, for the sake of argument, that I did tear up the jail suit. What if there were some mitigating circumstances involved? What if, as an example, the heat duct was on and it couldn't be turned off and the temperature was 100 degrees, and in order for me to keep from suffocating in the room, I had to take my jail suit off, tear it up and stuff it in the holes to prevent death or to prevent sickness or to prevent some kind of discomfort. That's an affirmative defense for me. And it destroys the very first word, because you see it says up here maliciously. So one of my options for defense then is maliciously, but on the other side of the coin, it is the burden of the prosecutor to prove not only that I tore the jail suit up, but that I did so maliciously. So what's the first thing we do when we take a look at a statute? The word maliciously. We're going to look it up in a law dictionary and find that maliciously means that it has to be done with some ulterior motive. There is a evil or wicked intent involved on my part. It wasn't that I tore it up because I was suffocating. I tore it up because I hated somebody, and out of spite or vindictiveness, I tore this jail suit up. Okay? So we know that then number one, as an issue of proof in their prima facie case, that they've got to show that there was evil intent. So write that down. Evil intent. That's item one. Now, injures or destroys any real or personal property not his own. Key words. Not his own. They're going to have to prove that that jail suit was theirs and not mine. So let's show ownership. So write down the word ownership there, or some other word that means the same to you. And then it goes on after the comma and says, in cases otherwise than such as are specified in this code. All right? Now, we're looking at 7001. Then there's 7002, 3, 4, 5, 6, 7, and 8. So if we take a look at the rest of the code, there may be some specified exceptions to this code. And remember, it's talking about personal property. Now, it could be shoes, it could be clothes, it could be any real or personal property, so it could be injury to a wall or the breaking of a door. You know, what if you were opening a door and the knob fell off in your hand? Is that malicious destruction of property, real or personal? Or is it an accident? You know, maybe we've got an accident here. So why don't we write down that word, intentional? I mean, this jail suit could have got torn up intentionally or accidentally. All right, then otherwise specified in this code is guilty of a misdemeanor. Now I want you to underline that is guilty of a misdemeanor, because that tells you there's the civil law. You notice it doesn't say anything about intent. Now if you'll take a look at Idaho Code 18-201, you'll find, and this is certainly true in all of the dictionary definitions, that crime, the word crime, entails two indicia, intent and an act. So if you have an act without intent or intent without an act, you don't have a crime. In this case, somebody has a contract or a license. Now, as an example, let's say that you're a contractor with the Department of Education and you're going into a school, and as a contractor or a subcontractor, you go in and you don't like the way the custodian told you to store the paper towels in the coat closet over there, and so, you know, just out of orneriness, you kick over a can of caustic soda on the floor, and it gets over on some books and papers and causes $500 damage. Now, because you have a contract with the school district, you're a party, you're a person who is, in effect, a quasi-employee of the state. This statute applies to you. But what if you're a free man and you're hauled in and thrown in jail? You see, you don't have any contract, either quasi-contract or any implied contract or any signed contract or license with the government, and the civil law cannot apply to a free man. So therefore, if they're going to bring you in on this particular charge, they've got to take you to the grand jury and have the grand jury with an indictment specify that you did in fact, or that they believe that you did in fact, cause this damage. The grand jury can bring you under this statute, but the civil law cannot. So, you can simply look at your status here, and this may be a fact that you're going to want to testify to. When you get on the witness stand, you're going to want to say, I don't work for the school board, I don't work for the jail, I don't work for the government, I don't have any licenses. And it's for those reasons, those facts. Now, that's what you want the jury instruction for, and you should have set this at the scene of the crime if it's at all possible, or in that period between the crime and the trial, you needed to be thinking about that. Alright, so we've got this number 3 then, is the intent or the intentional destruction of whatever it was that was destroyed. And remember, they're claiming you're guilty of a misdemeanor, and that can only occur if there was no intent. There had to be a license or contract. Unless the damage is caused by a violation of this section exceeding $1,000, in which case then it's a felony, in which such person is guilty of a felony and shall be punishable by imprisonment. Oh, $1,000 comes into play here, so value has to be shown. It has to be shown unless it's a misdemeanor. Now in this case, they're only showing a misdemeanor, so because of the misdemeanor, I don't have to worry about the $1,000, but what if they were charging me with $1,200 damage? Now they've got to prove the money issue, don't they? You know, when we go back to the writing of this statute, which occurred about 1949 or so, we find that $1 was worth substantially more in 1949 and was redeemable in lawful substance called silver in 1949, and that in 1983 there is another issue. So he's going to have to show that there was a value here of $1,000, and remember that the intent of the lawmaker is the law. And the intent of the lawmaker was $1,000 in 1949 dollars, not $1,000 in 1983 dollars. So if you caused $1,000 in damage in 1983 dollars, then what we want to attack is the fact that in 1949 it was worth 10 times as much. Therefore, that was $10,000 in 1949 dollars compared to 1983 dollars, and I didn't cause that much, so it's a misdemeanor. And you need to raise that issue because while the jury may not buy it and the judge and the prosecutor may not buy it, you're arguing the money issue, and when you move it into appeal, it's another appealable issue. Now, going on, it says, in which such person is guilty of a felony. All right, and so in this case, we're only talking about a misdemeanor, so we're not concerned about a felony, and shall be punishable by imprisonment in the state prison for not less than a year, no more than 5 years, and may be fined not more than $1,000, or by both such fine and imprisonment. So the fine and the 5 years in prison can only apply to a felony, and this is a misdemeanor, so $300, and I believe it's 6 months in jail for an ordinary misdemeanor here in the state of Idaho. So there are 4 items of the prima facie case that the prosecutor has to prove out of the statute. And that's the 4 that I picked out, and you'll be amazed. You get 3 or 4 people looking at a statute, and you may find a couple of more. But for the sake of argument, we have those 4. All right, now in addition to that, he has to prove where the crime was committed. So number 5, he's got to prove the location. Is it within the jurisdiction of Ada County? He's going to have to prove who did it. He's accusing me, so he's going to have to prove that the defendant did it. So there's the defendant. All right, now, what else is he going to have to prove in a prima facie case? Let's put our minds to this for a moment. Let's see. He's going to have to prove that it occurred in the jail and that it was the property. So he's going to have what? Physical evidence. Okay, so let's put down evidence then, right? And then at the mouth of 2 or more witnesses will a man be condemned, so he's going to have witnesses. So let's put down number 8, some witnesses here. All right, so let's just, for the moment, we may have 15 or 20 prima facie issues. I'm not sure how many we would have typically in this, or specifically in this particular case, but let's start off with these 6. We're faced then sitting on our side of the table. We need to watch the witnesses he puts on, the evidence and testimony that he puts on, and we need to put a little check mark out here. Let's suppose that he forgets to prove that the crime was committed in Ada County. He does everything else. He proves intent, he proves ownership, belong to the county, he proves that it's intentional, he brings in witnesses and they testify, he shows the value and he shows that I'm the defendant and I'm the guy that did it, but the one thing he forgot, and that was that it was committed within the jurisdiction of this court in Ada County. Well, what if the crime or the alleged crime was committed over in Cheyenne, Wyoming, and he's trying the case in Ada County, Idaho? He's out to lunch, isn't he? All right. So that's what we're looking for, because as soon as the state rests, that's the end of their case. And when the state rests, we're going to stand up and say, Your Honor, I'd like to make a motion at this time. And so you rise up as he is sitting down to make a motion, or to move the court for a motion to dismiss for failure of the state to prove the prima facie case. Now, he's going to bring certain witnesses. Now that we've covered this prima facie case issue, he's going to bring on, you don't know whether it's 1 or 6. If you've done your discovery work, which we did in here, we know how many witnesses he's going to bring. He's going to bring 1 jailer and 1 guard who's in the, or 1 other prisoner that was in the cell. So he's got 2 witnesses. Now, what physical evidence does he have in this case? Well, if we check discovery, we find that they've got the jail suit, a mattress, and what else did they have? I think that was it, a jail suit and a mattress. The jail suit is torn up into 11 pieces, or it's in 11 pieces, not torn, and he has a mattress cover. All right, so the state's got 2 witnesses, and so you write down here, number 1, witnesses. And number 2, the physical evidence. Now remember, you want to cross-examine these 2 witnesses. And what questions are you going to ask these 2 witnesses that are going to be testifying against you? That's where you get a separate piece of paper out, you see. Now, because of discovery, you know that Officer Honey was 1. And you know that prisoner Joe Baloney was the other. Now, I happen to have been there, and I know the words and the conversation and how the entire scenario came down. So I'm going to describe for you now what is in this case at the scene of the crime. And as I describe this entire scenario to you and give you the entire background, which will take a few minutes, I want you to picture yourself in the jail cell. And then, when we get all of this background information to you, we're physically going to act out this prosecutor's half of the case, and we're going to have Officer Honey and Joe Baloney testify. And they're physically going to testify here, and then I'm going to cross-examine them based upon their testimony. Because remember, I'm the best person in the world to cross-examine these people, because you see, I was at the scene. I know everything that went on there. I know whether or not I'm guilty. I know whether or not I tore the suit up. If I did, I know why I did and for what purpose and reason and how it came down and all of those details. So let me tell you the facts as they occurred, and then when we bring these people in, I'll show you how, as we acted out, how to cross-examine. This entire case that you're looking at here occurred, I think it was in November, as I recall, around November the 21st, when I was taken to jail for contempt of court. And someone tried to put me, no, I'll take that back. I remember now what this case was. It was on April the 9th. They took me to jail for not having a driver's license. And they wanted me to dress in the jail clothes. Now, since I hadn't been convicted and I wanted to test the issue of whether or not they could take my fingerprints and dress me in jail clothes, I refused to be booked in, and I cited all of my constitutional rights, and I told them about Davis versus Mississippi, and I said, I want you to get a court order before you do this. And they choked me unconscious, and they beat me up a little bit. They made me hurt, and they took my clothes off, and they poured me in to the jail clothes. How many people does it take to dress George Gordon in jail clothes? Just 2. Boy, I'm telling you, those big Marine guards, just 2 of them grab you, and they pour you in there like they do it every day. How many does it take to fingerprint George Gordon? Well, it takes 6, and they still didn't get the job done. So it takes more to fingerprint than it takes to pour you in a jail suit. Then they picked me up and dragged me down to a jail, or carried me down to a jail cell, and they put me inside. The moment they put me inside, I took the jail clothes off and threw them under the bunk. Now there I am in my underwear in the jail cell. There's 2 other fellows in the jail cell. These 2 other fellows don't talk to me, and I don't talk to them. During the course of the evening, that is from 7 to 10, 11, 12, along in there, 3 or 4 other fellows were brought in, so that by the time lights went out at 10:30, there were 6 people, including myself. 5 others, including myself, made 6, or in addition to myself, made 6, as of lights out. When the lights came on the next morning, there were 10 people in that particular tank or that holding cell, and that's the total number of beds that are in there. So at 3 in the afternoon, there were 3 of us in there. At 10:30, there were 6 of us in there. And between 10:30 and 6 o'clock in the morning, 4 more were added for a total of 10. Now remember that the jail suit was underneath the bed as of 3:30 or 4 in the afternoon, because I took it off right away. In the course of the evening up until 10 o'clock, the jail guards come in about every hour. So we know that the jail guards came in at 4 o'clock, 5 o'clock, 6, 7, 8, 9, 10, 7 times until lights went out. And we know that between 10 and 6 in the morning, 4 more people were added, so the jailers had to have come in at least 2 or 3 times to bring those people in, and they bring them in one at a time typically. So in all, the jailers must have come in there about 10 times. Now, there had to have been then a period of time when I could have physically had time to tear the jail suit up. Isn't that correct? But here's the strange part. You see, the jail suit wasn't torn up like you would tear a piece of paper. You know, if you tear a piece of fabric along the whoop and the wharf, like you would a sheet, it tears, doesn't it? But the jail suit wasn't torn through the fabric. The jail suit the next morning, when Officer Honey came in, was sitting underneath the jail bunk, or underneath one of the bunks, my bunk. And they're stacked 2 high, and I'm on the bottom one, somebody's on the top one. Where they're sewed together at the seams, there was a pile of rags under there, and there was 11 total pieces. Now, the jail suit itself has 15 total pieces, because during the discovery process, we went over and we took a look at the sealed package that had the pieces in it, and there was 11 pieces, not 15. But like my shirt, if we were to take this shirt apart, there'd be a piece here on the cuff, and there'd be a sleeve, and there's a seam here, and that would be a piece, and it's tied here. So there's 1, 2 pieces, and then there's a piece here, and then you see the pocket. That's a piece. So the jail suit was supposed to have 15, it had 11. Now, when Officer Honey came in the next morning to bring in our shaving supplies, etc., I was standing away from my jail cell, or my bunk rather, and underneath the bunk there was this clump or pile of jail suit, which I, the day before, had kicked underneath the bunk. And I was standing about 10 feet away, looking at my bunk, talking to another man who was brought in for drunk driving. And as we were conversing, Mr. Honey came in and said, "Smith, Jones, Johnson, Gordon, traffic court, let's go. Gordon, get dressed. Gordon, have you torn up your jail clothes?" And he turned around and he walked over to my bunk and he picked up a pile of rags and he came back and he said, "You stupid blankety blank blank, don't you know that this is a felony destroying jail property?" And he arrested me on the spot. Arrested me right there in my jail cell. If you don't think that was embarrassing, being arrested in front of 9 other criminals. I thought I was already under arrest and locked up in jail. And he read me the riot act and jumped up and down and pawed the ground and bit the bushes. All right. Then he grabbed me by the scuff of my T-shirt, led me down the hall, and later in the day they charged me with a felony, which was eventually reduced to this misdemeanor, which in turn was eventually dismissed. Now there's the essential facts that occurred. Now, what we need to do then is to cross-examine Officer Honey, don't we? We need to cross-examine Mr. Joe Baloney. And if you'll look in the back of this case, you'll see from the preliminary hearing. In that preliminary hearing, I examined Officer Honey, and I examined another policeman, as I recall, and maybe another witness that I've forgotten about now. But I examined these people at the preliminary hearing, and I was bound over to trial. Now, that preliminary hearing took the place of the grand jury. In other words, you see, when you go to a government trial, they give you the same form without the substance of the grand jury. So what we need to be looking for as the prosecutor presents his case is the testimony of Officer Honey. And aren't we going to want to ask Officer Honey where he was standing? And won't we want Officer Honey to put up on the blackboard the configuration of the jail cell? Where were the bunks? Where did he find the rags? And where was Defendant Gordon at the time? How was he dressed? Had anyone been in the jail cell during the night? How often? And then don't we want to get into the nitty-gritty of the fabric itself? Because what happened to all of the thread that was in this pile of rags? Did Officer Baloney or Officer someone else in the middle of the night come in and see George Gordon asleep in his bunk and take his jail suit from under the bed and put in a pile of jail rags under it, and then come in and frame him the next morning and accuse him of destroying the jail suit? Is that what happened? Or did George Gordon in some way have a razor blade or some other sharp object that he could cut the thread? Or was the thread in this particular suit the type that when you pull on it, it just unravels? And shouldn't we have an expert witness who can testify pursuant to the fabric itself to tell us whether or not that nylon fabric is terrible? And shouldn't we give a piece of the rags to Officer Honey and offer to let him tear a piece of nylon to see whether or not that particular kind of fabric will tear? And since none of the fabric is torn, but rather it's disassembled, don't we need some expert witness who can testify that the stitching in that type of a jail suit is not the kind of stitching that unravels, but rather when it's stitched in, if you were going to take it apart, you'd have to cut each and every thread? That's right. And those are the kinds of expert witnesses that the state probably won't bring in to prove that item. For instance, it isn't in the state's best interest to prove that I had a razor blade in the jail cell. It's not in the state's best interest to prove that it unravels, because, as a matter of fact, those jail suits are put together in such a way that they don't unravel. We tested it. None of the fabric itself was torn, only the thread was missing. And so what it appeared to me to be, and to others that looked at it, was that you had a disassembled jail suit, and they went in and picked up 11 pieces because they didn't know how many pieces were in a jail suit. And they stuck it under the bed, and then they charged me with a crime. That's malicious prosecution. Now, once that occurs to you and you are successful in defeating them in the courtroom, now it's Title 42 time. Malicious prosecution has to occur after, your civil case for malicious prosecution will have to occur after you've successfully defended your position. Now that you have the essential facts from my perspective as the defendant as to what happened, now we want to get into the trial itself. We want to get into the prosecutor putting Officer Honey on the stand and this fellow, what do we call him here? Joe Baloney, a fellow prisoner on the stand. He's the man that they claim was the person who witnessed me tear this apart. And we're going to want to cross-examine this Joe Baloney and see what his motives are, because, remember that Jesus Christ was convicted at the mouth of 2 false witnesses, wasn't he? And remember the Miranda doctrine, how it's commonplace for the police to bring in false witnesses? And don't we want to get in the Miranda doctrine, the law of the case of Miranda that talks about Mutt and Jeff to the jury? And don't we want to get that in the form of a jury instruction so that the jury will know about the Mutt and Jeff routine? So that the jury will be informed that it's not uncommon to charge a man with a crime and then reduce the charges in hopes of so intimidating him that he'll plead guilty? Don't we want the jury to know that? And what are the jury instructions that we want that jury to know and to see?